I need
Ms. Dickerson, how are you?
I'm good. How are you? Can you see me?
I can see you and I can
Okay.
hear you.
Okay, perfect.
Able to see the board chairs,
Yes, ma'am.
see each other, we can hear each other, so that's great.
Okay.
Board is now, so they should be in a few moments.
Okay, yes, ma'am. Get down. No.
Yeah. Oh. Oh.
so helpful.
All right, thank you. I want to welcome everyone this morning. The first thing we're going to do is have a brief moment of silence and a word of prayer. So I'm going to ask Miss Nancy if she would lead us in that.
Lord, thank you this morning for letting us be here. We ask you, God, to guide us and lead us today and help us make the decisions that we need to make. We thank you, God, for another beautiful day. Go with us today. In Jesus' name, amen.
Amen.
I will, we're ready to go on the record. Ms. Ashley, thank you. I want to make a few introductions. First of all, I'm Mary Stewart. I am an RN member of the board, and I want to tell those of you that are with us, this is a board that is made up of 13 members. There are 7 RNs, 4 LPNs. We have 1 physician member and 1 consumer member. Today, we are a 3-member panel of the board. I will be serving as alternate on this first case. I will not participate in either the deliberations or the decision concerning this case. I want to introduce the board members, actually ask them to introduce themselves.
Sandra Culpepper, LPN.
Nancy Norris Johnson, LPN.
Laura Moore, APRN.
Thank you. And I also want to take a minute to introduce the Special Assistant Attorney General, the Honorable Edward Higgins, to my right, who will be leading us today.
Good morning, everyone.
Good morning.
And then Mr. Wesley Mutzeiger, who is attorney for the board. And I believe that's all of our introductions. Okay.
All right, thank you, Dr. Stewart. Now before the Mississippi State Board of Nursing is the matter of Shaleria Palmer, license number P326161. As stated earlier, my name is Edward Wiggins. I will serve as the hearing officer. My role is to direct the course of these proceedings, to rule on objections to questions or evidence raised by the parties to the hearing, to see the orderly process of the proceedings and that the proceedings are conducted in accordance with applicable laws and rules. We've already had our introduction of our board members, so thank you for that. Is the licensee present?
Yes, I'm present.
Please state your name for the record.
Shaleria M. Palmer.
Will you confirm that you received notice of the complaint?
Yes, I confirm.
Are you represented by counsel?
Yes, sir, I am.
My name is Thomas
I will
Powell.
advise- Thank you, Mr. Powell. The hearing will proceed as follows. We'll begin with opening statements, if any. The case against that licensee will proceed. You'll be allowed to cross-examine any witnesses testifying against you, present testimony, evidence and rebuttal, or otherwise to respond to the charge in this application. Questioning of the witnesses will start with direct examination, followed by cross-examination, redirect examination, and finally with any questions by members of the board. At the conclusion of the presentation by both sides, closing statements will be allowed. The board will make findings of fact and conclusions of law and will render its decision in the matter, a copy of which will be sent to the licensee. At this time, I'll ask that any witnesses be sworn in.
None for the state. Or rather, actually, the state would reserve the calling of Ms. Palmer as a hostile witness.
Ms. Palmer, would you raise your right hand, please, ma'am, to be sworn in?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you're about to give in this cause to be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Since it appears that we only have one witness, counselors, is necessary to have any rule invoked?
No need. for
No,
the
it's
state.
not necessary.
All right, thank you. For the record, I will announce that there is a quorum present. I will also remind you that these hearings are open to the public. The board may deliberate and make its decision in executive session. At this time, are there any preliminary matters, council?
At this time, the state would move that exhibits B1 through B9, as well as respondents exhibits R1 through R3 be admitted into evidence.
Any objection, Mr. Powell?
Yeah, I object that Ms. Palmer only received the exhibits last night, so it's not timely.
Do you have any issue with any of the exhibits that have been provided?
Mm, no.
Okay, we will note the timing of those exhibits that have been submitted, but we will otherwise admit those exhibits. At this time, we'll begin with opening statements. Powell, you may proceed.
May I
Well,
ask a question? And forgive me for interrupting, Mr. Powell.
go ahead.
As this is a complaint-based case, it is customary for the state to proceed first. However, I would, if the respondent first present their case first, the state would not object.
Well, the only thing I would like to say is that based on the complaint that I've seen, that Ms. Palmer's case is covered by 99-15-26 of the Mississippi Code annotated, in that she did enter a guilty plea in the Hinds County Circuit Court, but that guilty plea was not accepted, and she has not been found guilty of a crime. Therefore, this matter should be dismissed as a matter of law. That's all I have.
Thank you, Mr. Powell. Did you have any examination for your client?
No.
Counsel for the state, you may proceed.
Thank you. Ms. Palmer, please state your name for the record.
Shaleria Martina Palmer.
And Ms. Palmer, you have in fact had a complaint issued against your nursing license. Is that accurate?
Yes, sir.
Okay, and just for a matter of record, Ms. Palmer, would you please recite the legal violation and specifics of the charge levied against your nursing license?
Professional misconduct.
So professional misconduct, isn't it in fact Mississippi Code annotated 73-15-29-1K, and that you engaged in conduct likely to deceive, defraud, or harm the public?
Not that it was approved by the judge. No, it was not.
Okay, so ma'am, my question is regarding the complaint issued by the Board of Nursing. Is the charge against you that you engaged in conduct likely to deceive, defraud, or harm the public?
Is that the charge?
That is the question.
No, that's not the charge.
Okay, ma'am, I'm going to point you to exhibits B5, please. Contained in exhibit B5, you see two complaints, one dated June 26, 2020, as well as one dated August 27th, 2020.
Yes.
On the second complaint, the one dated August 27th, 2020, that first, or excuse me, rather the second page, you see the document that says complaint in the heading in the middle of the page.
Yes, but you asked me is that the charge? No,
Yes,
it's
ma'am.
not.
If you please direct your attention to charge one. Would you recite that for the record?
I see B5, it says Mississippi Code 73-15-29-1. This is B5.
Yes,
So am I
ma'am.
looking at something else?
Please read the charge in its entirety.
I have a notice here, a mailing notice, so I'm trying to make sure I'm on the right page with you. You said exhibit B as in boy 5, right?
Correct.
Okay, so this is a mailer that says, "Dear Ms. Palmer, please take notice that the charge that are being brought against you to seek disciplinary action against your license to practice nursing in the state of Mississippi specifically, you are being charged with a violation of the Nurse Practice Act, Mississippi State and Code, Section 73-15-29-1, 1972. See attached complaint." I don't have an attached complaint. You are hereby ordered to appear before the Board of Nursing. Now, if you're saying the second
Ma'am.
page,
Is it your testimony, Ms. Palmer, that you did not receive the complaint dated August 27, 2020?
I have the one that was mailed June 26th, the one that was mailed, it does not, I have the notices. It does not specify what the charge is. That's what I'm saying. I
Okay,
don't have the
so-
specification of the charge. I just have the Mississippi codes.
Okay, very well. Well, we will clear this up later then, Ms. Palmer, regarding service of process of delivery of the complaint for which the board has sufficient evidence.
Okay.
So, Ms. Palmer, what I'm looking at and what I have provided to you, the exhibits that has been mailed to you, certified mail 2 times previously, at least 2 times previously,
Yes,
contains charge 1 on the second page, notice of hearing and complaint. So in the documentation that you were provided yesterday evening, you
yes,
should have as exhibit B5. And if you will follow along with me, in the complaint, August 27th, 2020, the second page, upon which there is a heading saying complaint. Do you see with me charge 1?
yes, on B5, that's not the second page, it's the 4th page. Yes, I do see that. 5th, 6th page down for
And it
August
is-
27th, yes.
Thank you, Ms. Palmer. And could you please, once again, recite the charge contained there on that complaint?
The charge says the respondent violated Mississippi Code and State Section 73-1529-1K, and the respondent engaged in conduct likely to deceive, defraud, or harm the public.
Ms. Palmer, is that the charge that you're facing today?
With the nursing board, I was told professional misconduct. So yes, if this is your complaint, yes,
Thank you.
thank you.
Okay, Ms. Palmer, specifically regarding that charge, it does in fact further state specifically that you submitted an LPN renewal application to the board on or about December 29, 2017. Is that accurate?
Yes,
Further, the complaint alleges that you answered yes to the question, do you currently have any pending criminal charges? Was that accurate?
yes,
Okay. Is it also accurate that you pled guilty to felony false pretense in Hinds County Circuit Court, Mississippi, case number 17-0-622?
my guilty plea was withheld, so no, sir, that's not accurate.
So you did not plead guilty at any point in the proceeding before the criminal court?
The judge did not accept it, so what I pled does not matter if she didn't accept it.
And
By law.
that's not my question. My question is, did you plead guilty?
Did I go there? Yes, I did.
Thank you. Okay. Next, the court entered an order of non-adjudication, as you state, placing respondent on probation for a period of 2 years in order to pay restitution in the amount of $1,739.31. Is that also accurate?
That's accurate.
Okay, thank you. Ms. Palmer, I would now direct your attention to Exhibit B6. And further, for that matter, Ms. Palmer, when we're taking a look at these exhibits, you would agree with me that Exhibit B5 is, and I'm looking at the exhibit list, if you wish to follow along. Exhibit B5 is in fact the notice of hearing complaint, proof of service. Is that accurate?
That's accurate.
Okay, so B6 is the Hinds County, Mississippi Circuit Court indictment. Is that accurate?
That's accurate, yes,
Have you seen that indictment before?
I have.
Are you familiar with that indictment?
I am.
Okay, thank you. Exhibit B7, Hinds County, Mississippi petition to enter a plea of guilty, non-adjudication, case number 17-0-622. Is
Yes.
that accurate?
It is.
Have you seen that petition to enter a plea of guilty before?
I have.
Are you familiar with that petition to enter a plea of guilty?
I am.
Okay. Exhibit B8, Hinds County, Mississippi Order of Non-Adjudication, dated January 13, 2020. Is that accurate?
Yes, where it says the court withholds a guilty plea. Yes, it is.
Yes, ma'am. And in fact, are you familiar with that document as well?
I am.
Would it be fair to say then, Ms. Palmer, that you have previously reviewed Exhibit B6, B7, and B8, and they are not new documents?
They are not.
Thank you. Okay. So, Ms. Palmer, I now want to direct your attention to Exhibit B6, the Hinds County, Mississippi Circuit Court indictment.
Mm-hmm.
In fact, Ms. Palmer, is it true that the Circuit Court of Hinds County indicted you on or about July 27, 2017 for the charge of felony false pretense?
It was, yes, that's right.
Okay. And in fact, they allege that on the 26th day of September 2016 to the 21st day of November 2016, Shaleria Palmer knowingly, intentionally, feloniously, and with the intent to defraud Tyson D. Dixon and or Bank Plus did designedly, by color of any false token or writing, or by another false pretense, obtain from a banking corporation money, personal property, or valuable things with the value of more than $1,000, less than $5,000, to wit, $3,478.62 by using the Bank Plus account of Tyson D. Dixon to pay personal bills for goods or services, or to take the lawful United States funds from said account in violation of Section 97-1939 of the Mississippi Code of 1972 amended. Is that correct, that you were indicted on those charges?
That is what the indictment states, yes, sir.
Thank you. Now I would direct your attention to Exhibit B7, Ms. Palmer. B7 we previously identified as your petition to enter a plea of guilty, to which you
Yes.
have stated that you did in fact enter a plea of guilty, albeit withheld acceptance by the court.
Yes, sir, I did.
In examining Exhibit B7, I would direct your attention to number 3 on page 1 of Exhibit B7, wherein it states, "I plead guilty to the charges of," and please, Ms. Palmer, what does it state there in number 3?
It says, "I plead guilty of the charge of false pretense."
As set forth in the indictment and cause number 170622, correct?
Yes.
Further, would you please read for the record number 4 on the first page of Exhibit B7?
I have told my lawyer all of the facts and circumstances known to me about the charge, and in the indictment, I believe my lawyer is fully informed me of all such matter. My lawyer has advised me of the nature of the charge and possible defense that I may have to the charge. I understand that I may plead not guilty and may persist in the plea as the Constitution guarantees me the right to a speedy and public trial by jury.
Thank you. So in fact, you understood, well, I guess first we should make clear, you understood that you pled guilty by signing this document, right?
No, I do not understand that, because my guilty plea was not accepted by the judge. I have went to court before and filed and pled guilty, and has been found not guilty. So whatever the judge decides is what is law. It's not my decision. If I can plead guilty and the judge says I'm not guilty. I have not been convicted. There is no conviction on my record.
Ms. Palmer, I'm not fighting you on the fact that you
Okay.
don't have an adjudication of that guilt. Okay.
I don't have any part of that guilt. I don't have to acknowledge that guilt anywhere unless I violate those terms within 2 years, and I have not. So therefore, I have not been found guilty of anything. And the State Board of Nursing says that I have to be convicted of a felony charge within 5 years, and I have not. So no, I have not been convicted, adjudicated, or non-adjudicated.
Okay, Ms. Palmer.
Counsel. Mr. Powell?
Yes.
would you ask the client to respond to the question, and if she has any additional comments, she can make those.
Okay, her answer is she has not been convicted of a crime.
Okay, well, I'm just asking that she respond to the question that is asked, and then if she has
Okay.
any additional comments, she can make those.
Yes, sir.
Thank you.
As a matter of record, it is correct, Ms. Palmer. You submitted this petition, is that right?
Yes, I did.
Submitted the petition, entering a plea of guilty to false pretense, understanding that you had the opportunity to plead not guilty. All right. Next, Ms. Palmer, I would direct your attention to page 3 of Exhibit B7. Would you please read for the record number 14 on page 3 of Exhibit B7?
My lawyer advises me that the elements of the charge which I am pleading guilty are follows. Count F, on or about September 26, 2016 to November 21st, 2016, in Hinds County First Judicial District, did knowingly, intentionally, feloniously, by false pretense, obtain from a banking corporation money in amount more than 1,000 but less than 5,000, the property of Tyson Dixon in the violation of section 97-19-39.
And please continue reading.
I submit the following facts, which I state to be true, and feel that all of the above elements are proven by these facts, same as above.
Let's pause. Ms. Palmer, you submitted this petition. You understood, you were advised of your rights, your ability to plead not guilty, yet you plead guilty in a document stating that I submit the following facts, same as above, which you just read, that you
Yes.
state to be true and feel all of the above elements are proven by these facts. So let me ask you a very straightforward question, and please listen carefully, Ms. Palmer. Regardless of conviction, okay, I'm not talking about whether you've been adjudicated. You plead guilty because you in fact committed the violation. Is that correct?
No,
No. So you pled guilty. Why?
because I have no way to prove that I wasn't guilty because my person that accused me never would come to court. We went there 4 times. He never showed up.
And so what are we to believe, Ms. Palmer? You submit a formal petition with the Circuit Court of Hinds County stating that you submit the
It's
following.
a best
facts.
interest plea.
Palmer, may I please finish my question?
Okay,
Thank you.
no problem.
I submit the following facts, which I state to be true and feel that all of the above elements are proven by these facts. I didn't execute that, Ms. Palmer, you did. And so now it's your assertion today before this board that what you put forward before the Hinds County Circuit Court is in fact not true or inaccurate by penalty of perjury. In fact, paragraph 15 states that I understand I'm presenting a petition under oath and under penalty of perjury for any false statements contained herein. What is the board to believe?
No, sir, I'm not saying that that's not accurate. I'm saying you are accurate. That's what I pled to, but that's not what the judge agreed to. That's not what the judge entered, and she is the judge. I only pled. She withheld it because she didn't even, with the facts presented to her as the judge, she had a decision to make. And the decision was that by the facts and the time, because I do have the right to a speedy trial, it was not there. I waited from 17. I kept going back to court. We filed for motions for speedy trial. It never came in. I went in fact, to try to do what was a best interest plea to get this situated so I wouldn't have a problem with the nursing board if I was to move out of town. So yes, I went in and the judge withheld a plea.
And again, Ms. Palmer, not fighting you on the fact that you're in an order of non-adjudication. I completely take notice of that. Rather, I'm simply establishing that you, in fact, did enter a guilty plea, albeit withheld. You entered a guilty plea. And I would just be curious if you would assert today that you did not understand what a guilty plea meant.
No, I understood
No.
exactly what a guilty plea meant, that it was
Excellent.
non-adjudicated.
Because in fact, according to Black's Law Dictionary, a guilty plea is an accused
That in the
person.
exhibit,
Ma'am, it is
if
not.
it's not in the exhibits, you can't enter that.
I would ask that the board take judicial notice of Black's Law Dictionary.
It wasn't presented in my exhibits, so I don't have that at all present, so I cannot look in that. So I asked the judge to strike that and not be able to allow him to use that. I don't have a copy of it and I can't see it for myself.
Mr. Powell, as her attorney, do you have any comment on that?
Yes, I mean, like I said, at the beginning, I said that she only got the exhibits last night and we don't have that exhibit.
Okay, it's my understanding that the definition is not an exhibit.
That is correct, Mr. Wiggins. Black's Law Dictionary is a universal resource applied by the legal profession, much like the Webster Dictionary is for the English language. This is not an uncommon, unavailable piece of information. This is widely available and accessible to all general members of the public. And of course, here, Ms. Palmer, represented by counsel, of which I'm learning today, represented by counsel, should absolutely have no objection to simply stating for the record the widely accepted definition of guilty plea in Black's Law Dictionary. How could that possibly be prejudicial to his client?
Mr. Powell, you can proceed.
Well, I mean, the problem I have is that the council here is trying to skirt the law in that if the non-adjudication statute and the other statutes allow for a non-adjudication or a best interest plea, and he's trying to act like he doesn't understand that and say that she's in a guilty plea, and that's not technically what has happened here.
Okay, my question, Mr. Powell, is do you have an objection to Black's Law
The
Dictionary?
definition?
Yes, sir.
No, he can read the definition, that's fine.
Okay, we'll take judicial notice of the definition. You may proceed, counsel.
Thank you. Guilty plea. An accused person's formal admission in court of having committed the charged offense. And again, Ms. Palmer, take full notice of the fact that you're in an order of non-adjudication, but rather that is not the entire story of the proceeding today. Lastly, before we move on from Exhibit B7, Ms. Palmer, if you would please, and again, not trying to belabor the point, I just think it's important that the board understand the petition that you submitted in Hinds County Circuit Court. That same page we were on, page 3B7, that first line above paragraph 15, please read it for the record and we will move on.
Therefore, I am guilty and ask the court to accept my plea of guilty.
Thank you. So next, I would then go to Exhibit B8.
Okay.
So Exhibit B8, Ms. Palmer, we in fact, we've already established that that is the order of non-adjudication. And if you could follow along with me on Exhibit
Excuse
B8,
me.
page 2.
I want to read the order. What does the definition of non-adjudication mean, since he has the definition of it?
I'm sorry, what am I waiting on?
I was going to ask that since you have your, yes, can you hear me? I'm sorry.
Ms. Palmer, yes, but this is not the time for you to ask questions. This is the time.
Okay,
for
go
you to
ahead.
ask questions.
We're ready, go ahead.
All right, Ms. Palmer, page B8, excuse me, Exhibit B8, the first page, the second paragraph, now comes the defendant in his own person represented by counsel and withdraws the plea of not guilty to the charge heretofore entered and enters a plea of guilty in the charge of false pretense. That's there on paper. Is that accurate?
It is.
Thank you. The The court, having first duly advised defendant of all your legal and constitutional rights, and having freely and voluntarily and intelligently waived said rights in the premises, court having further advised defendant of the consequences of a plea of guilty, and therefore, upon direct questioning, having admitted that he is guilty of the crime to which he has pleaded guilty. So again, I understand you've withheld it, but there's a plea entered. There is language in B7 and B8. You're represented by counsel clearly stating you admitting to your guilt of these violations, albeit withheld. So Ms. Palmer, let's get to your argument, okay? Because I know your argument. I think we've kind of beat it a little to death already. And that is that you have concern that there's been no guilty plea entered. Well, did you in fact present a case to this board for consideration contained in Exhibit R3 today?
You said R3?
Yeah.
You said Exhibit R3?
That is correct.
Yes,
Okay, so you've submitted that on your behalf, is that right?
yes.
So Ms. Palmer, do you understand that a criminal matter, while an adjudication may be withheld, it may have consequences that reach beyond the criminal realm? Do you understand, by virtue of having a nursing license, that you are held to a higher standard than the average ordinary citizen?
I do.
Understand that you are held to a standard that you shall not engage in professional misconduct, of which not is alleged, but also that you shall not engage in conduct likely to deceive or harm the public. Do you understand that?
What I understand are the rules of the nursing professional license that the nursing board has that are not what you're stating. Those are not listed, but I do understand that I'm held to a higher standard,
Okay,
and I
so
have withheld this standard for 10 years.
Ms. Palmer, it's your testimony that the charge is not listed. Can the board please take judicial notice of its very own statute defining what shall be considered a violation or unprofessional conduct or grounds for disciplinary action, notably Mississippi Code annotated section 731529(1)K, wherein it states that a nurse shall not engage in conduct likely to deceive, defraud, or harm the public? I would ask that the board take notice of that.
The board says conviction. Not
Okay,
none of
moving
your-
on, Ms. Palmer, moving on. You provided a case, Exhibit R3 today. I'm going to direct you to page 3 of the case which you presented. Ms. Palmer, I'm going about 3/4 of the way down. And I would ask that you read for the record the paragraph starting with "we find" and ending with "charge."
We find that the tribunal applicant of the respondent's reliance of the Baker's factor inapplicable to this case. First, the case sub justice is not a criminal case. The respondent has higher duty than that of a criminal defendant. He is, after all, a lawyer, a member of the bar, and the person responsible to his clients, the courts and the bar, and found responsible at the public at large. It is unseen for a member of the bar to assert and argue a criminal defense in a hearing concerning a professional misconduct charge.
So that's right on point, Ms. Palmer. Do you see whereas an attorney has a higher duty than the average person, that in fact a nurse also has a higher duty by virtue of membership in their profession than the average ordinary person? Do you understand that?
I understand that.
Do you further understand in the case law that you provided today that in fact the Mississippi Supreme Court takes note that it is unseemly for a member of the bar, or as in this case, a member of the nursing profession, to assert and argue a criminal defense in a hearing concerning professional misconduct? Do you understand how your conduct, while may not resulting in a criminal conviction, by virtue that it exists, by virtue that you pled guilty, that you acknowledge that it occurred, that in fact you are still responsible for that conduct to the Board of Nursing?
No, not if I have been non-adjudicated of it, because for some reason that the judge felt that I was not supposed to be convicted of that. You were not in court. You don't have the transcript from the court and why she withheld it. So no, I do not. Had it been something where I gave a wrong medication or I killed a resident, yes, I do understand that. But for the absolute longest, since 2011, I have upheld that part of my nursing license. And I cannot, because this is not a court hearing, you're saying that it's not a criminal defense. You don't know all the facts. You're going by what you see on paper, but you don't have the transcript from the court of why I could not separate myself from the charges. I was not even there. In fact, nowhere near the situation. I could not cross-examine. I could not do anything. But because Mr. Jameson of the nursing board told me I needed to get it cleared up, I had to do something which was in my best interest, which was to take a plea of non-adjudication because I had no fault in this situation.
Okay, so
So yes, I took a plea.
I have one final question for you, Ms. Palmer. Is it your belief that someone who enters a plea of guilty, acknowledging and accepting responsibility for the indictment as alleged, even if not convicted, if someone enters a plea of guilty for felony false pretense, that they should be exempt from disciplinary action for the Board of Nursing?
Yes, if the judge does not agree with that, yes. If the Board of Nursing does not convict it, does not have that in their laws, saying that this is grounds for disciplinary actions, yes, I do.
With all due respect, Ms. Palmer, we have it in our laws, and that's why we charge you with
Okay,
70
so can you show me?
Ms.
Because I'm
Palmer,
looking at the nursing, the professional license and the part and the rules, and the first thing says conviction of a felony within 5 years. Can you show me where it says that non-adjudicated anywhere? Can you show me?
Ms. Palmer,
I have no further questions for this witness.
Mr. Powell, I would ask that you direct your client to respond to the questions that are answered. If you have any examination you'd like to conduct at this time, Mr. Powell, you may proceed.
One moment, please. Okay, Ms. Palmer, let me ask you, when you entered this guilty plea, were you, had your lawyer talked to you about a best interest plea?
Yes,
Okay, and what is your understanding of a best interest plea?
that I needed to do what was in the best interest of my personal and professional license.
And that's including even if you are not guilty of a crime, but you cannot prove that you're not guilty, you do a best interest plea, is that correct?
That's correct.
Okay. And when you did your plea before the court withheld your guilty plea, is that correct?
Yes, sir.
Okay. And they said they gave you a probationary period at which time the charges would be dismissed, is that correct?
As long as I didn't violate the charge, the grounds, yes.
All right, and after that, would these charges be cleared or removed from the computer where no one would ever even know they existed?
They'll be expunged. They won't even show up on my background check now.
That's all the questions I have.
Thank you, Mr. Powell. Any redirect, counsel?
No, sir.
Any questions from the board?
Ms. Palmer,
Yes, ma'am.
question. Whenever, were you present on the day that the judge ruled on your case?
Yes, I was.
Did she speak or he or she speak specifically to you about why she made the decision that she did?
Yes, ma'am, she did.
And would you mind sharing that with us?
Yes, ma'am. She asked me to tell her in my own words what happened regarding this situation. And when I told her this situation was me dating a guy and he having a best friend, that they got into an argument. He borrowed $5,000 from me. He was supposed to pay it back. He gave me his debit card or whatever. I paid bills. It was no problem. We had no issues. He and the best friend, Deontay Miller, got into an altercation where Deontay and Tyson had got into a fight. He went to the bank and he said, well, Tyson got on cocaine and told the bank that he didn't authorize any of the charges. So the bank had no other choice, because he agreed that the charges were not made by him, to prosecute. The co-person is on the bank, Tawana, whatever her name was, she agreed. She told the judge that no, Ms. Palmer, this is a loan. He didn't pay back. He wanted the money back. But what him and Deontay had going on had absolutely nothing to do with me. But because Deontay and I dated, that it was like I was acting in concert. I wasn't even living with Deontay, was not, having no dealings, but because we had a house together and the bills were in my name and his name, that they're saying that we acted in concert, and I never took $1 from Tyson. I actually only didn't even get $1,600 out of the $1,500 the $5,000 that he owed me, because I only got $3,400 back. So the judge, after she noticed Tyson to court 4 times, we had to do continuances because he would not show up at all. So 3 years into this thing, I was ready to do it in March of 18. He didn't show up. January, March, October 19. All of this happened and he still wouldn't show up to court. So when I knew I was going to be working between Mississippi and Georgia, and Georgia's Department of Health had a stipulation that you had to, if you had any previous thing, you had to go ahead and have it settled, then I did it because it was in the best interest to move me and my children out of Mississippi. So when I asked the judge, she said, Ms. Palmer, I'm not going to find you guilty because I feel like he's not here and he hasn't shown up, and you have the right to a speedy trial. This is 3 years, and she told me it really was supposed to be 2 years and some days that he had to do this. I went to the court myself and asked them if I could take a plea to get it settled to move. So she told me, she said, no, we are not going to find you guilty because I believe what you're saying. Deontay never showed up for court because he knew he had guilt. I didn't even know what had happened. When I went in for the investigation, they were taped. The investigator asked me, did I know any of the people? I did not know any of the people that they were referring to because I had separated from Deontay 6 months prior to. I found out about this charge in March of 18 when they came in, when they picked me up, March, I think the 5th or something. I knew nothing about this at all. So when they asked and when they tried to figure out, did I know anything? They found out that Deontay was defrauding his friend, and I knew nothing about it. But the charges that he had, the charges, he went back to the bank and just said, oh, I didn't agree to any of these. He pressed charges on his mama, his baby mama, his Deontay, and myself. And I went to him in April and he told me, yes, he'll show up for court. He never came to court. So I went to Mr. Roth and asked him, can we enter a plea and try to figure out what can I do in order to get this settled before I leave Mississippi? And that was the agreement. And I asked the judge at that time, what does this mean? And she told me, she said, it means that unless you violate one of these terms, that I'm withholding your guilty plea for a period of 2 years. And I asked her, what would it do for us, my voting rights? I didn't even think about not just the nursing board. I wanted to know about my voting rights. She said, you're not a convicted felon. You don't have any reporting probation. You have to pay restitution. And unless you violate one of these terms, basically, I don't even have to disclose it.
Thank you. Are you currently still living in Mississippi or have you moved to Georgia?
I live in Georgia 98% of the time. I still have my home here. I still have a business here. I'm taking care of my grandmother. My dad just died. It's a lot. I'm going back and forth. I'm here in Mississippi right now.
Are you working currently in Georgia?
I'm working in an agency that I work from Georgia, Arizona, Mississippi, and New York. I'll be in New York.
Are you employed as an LPN in that?
Yes, ma'am, I am.
Okay. Thank you.
Any further questions from the board?
The state would have a follow-up question to the response provided by Ms. Palmer.
Ms. Palmer, was Deontay charged in this matter?
Yes, sir, he was.
Okay, so he didn't show up for your matter or his?
No, sir, he did not.
Counsel, if you have some redirect.
I do. Ms. Palmer, you just stated that you were not aware of this matter until March 2018. Is that accurate?
Yes, I mean 2017, I'm sorry, 17.
Okay, 'cause that is indeed my question, because you in fact submitted an LPN renewal application to the board on or about 12/29/17, where you
Yes.
indicated pending criminal. Okay, very good.
Yes, it was March of 17, I'm sorry. I was arrested when I was in court.
Anything further, Mr. Powell?
There's nothing further.
The state will call Floyd Wiley. Chair on over.
Mr. Board.
Mr. Powell, you have a question?
Yeah, I thought we said that there were no other witnesses that were gonna be called.
The state is calling Mr. Wiley in response to allegations made by your client that she did not receive a complaint. Mr. Wiley is being called not in the capacity to testify to any evidence regarding the criminal matter, but rather as to the procedural requirements as set forth in the complaints containing the exhibits which have been admitted into evidence.
Yes, sir. She, when she was looking at the exhibit, she just didn't read all the pages, but she did receive the complaint. We'll stipulate to that.
Okay, thank you. There will be no need then, if counsel is willing to stipulate the receipt of the complaint, no need to examine Mr. Wiley.
Okay, thank you, counsel. Please let the record reflect that the stipulation is noted. Anything further from you, Mr. Powell?
No, sir.
Counsel? Any further questions from members of the board? All right, closing arguments,
Okay.
or statements rather.
All right, just one moment, if you will. The board charges Ms. Palmer with violating Mississippi Code annotated 73-15-29-1K, and that she engaged in conduct likely to deceive, defraud, or harm the public. Ms. Palmer erroneously asserts today that the board is relying on a charge of conviction of a felony, when that is not indeed the case. The board does in fact have administrative code regulations that speak directly to conviction of a felony. The board intentionally chose not to pursue that charge. The board takes notice and recognizes the fact that there has been no conviction and may be no conviction. What the board does recognize, however, is that there has been a plea entered, a plea of guilt to felony false pretense. Felony false pretense absolutely has nexus to the practice of nursing. Nurses have unfettered access to patients' protected health, private information. They have access sometimes to personal belongings. Honesty, integrity, these things are fundamental to the practice of a nurse, and we must ensure that these persons have these qualities and maintain these qualities if they are to practice this profession. By virtue of entering this profession, Ms. Palmer is held to a higher standard. She earned that privilege, and we have rules, regulations, and laws that govern that privilege, that govern that license, that hold her to that higher standard. That's why we as a board act to maintain and enforce those standards. Just because Ms. Palmer may indeed not have a criminal conviction does not absolve her of the conduct that has occurred. I put before the board today that the guilty plea is more than sufficient. The guilty plea, as I've gone over extensively in all the documentation, was made by Ms. Palmer under advice of counsel. There are several recitations in multiple documents noting the understanding that she had the right to plead not guilty. The fact that she understood she was entering a plea of guilty, that she understood that this was a truthful plea, that there was in fact evidence to support this plea, all at the penalty of perjury. I don't assert today that that a criminal conviction is necessary for disciplinary action. That would hamstring the board. We are not charged with only regulating criminal behavior. We're charged with regulating professional behavior. The behavior exerted by Ms. Palmer by her own guilty plea is unprofessional. It's in violation of 73-15-29-1K. Ms. Palmer's own case law, I think, is perfectly on point. The case sub judice is not a criminal case. The respondent has a higher duty than a criminal respondent. They're talking about an attorney here, but the same principle is easily analogized to our situation, a nurse. He is, after all, a lawyer, or Ms. Palmer is, after all, a nurse, a member of the bar, a member of the nursing profession, and a person responsible to his clients, the courts and the bar, a person responsible to the patients she treats, the employer that she works for, and to this regulating body. And finally, responsible to the public at large. And of course, as you all know, you are responsible for protecting that public. It is unseemly for a member of the bar or a member of the nursing profession to assert and argue a criminal defense in a hearing concerning a professional misconduct charge. It has no relevance in this matter today. No relevance whatsoever. Ms. Palmer engaged in the conduct, therefore she should be held accountable for that conduct. I would put to the board that it would be appropriate for Ms. Palmer to have disciplinary action imposed on her license in terms of a course of legal aspects of nursing, an ethics course, and that she comply with her criminal probation. I am not putting forward that she lose her nursing license, albeit I, of course, submit to the wisdom of this board to make that final judgment. But at a minimum, she should comply with her criminal probation. She is under criminal probation, and this board has a duty to ensure that she complies with it. Thank you.
Thank you, counsel. Attorney Powell, you can proceed.
Okay, yes, I'd like to say that Ms. Palmer has been an active member of the nursing community for over 10 years with no violations. And counsel wants to argue that she's guilty of a crime, but the statute, the non-adjudicated statute, that's what the purpose of that statute is for situations where a person may not be guilty, or it may be a best interest plea, and the statute allows to non-adjudicate those charges and erase them at the computer like they never happened. And if you're going to allow someone to, how are you going to take someone's license when the charge is not even going to be in the system anymore? And it's not going to even be a record of it. So, I mean, there will be no conviction. This issue does not raise any nursing concerns with her patients. She has not taken money from her patients. She has not given them medication falsely or wrongfully. And like we would just say, if there's no record of the charge and the charge is going to be erased at the computer, how are you going to use this charge to take her license? And that's all we have.
Thank you, Mr. Powell. As we sit here today, is Ms. Palmer on probation, or what is her status?
No, sir, I'm not. I had a non-report, non-paying probation. I don't have a probation officer. I had to pay restitution. I paid it in full in March, and the judge just told me because of the 30 for 30 that was given on the probation, January the 13th, I think, of 2021, I would no longer be on probation at all. So technically, I'm not on probation, but I'm on, I don't get it.
It's non-reporting.
Non-reporting, but it's actually up in 2021, not 22.
And it's up in what date in 2021?
I think it's the 13th. I need to look at the actual day of my sentencing. I think it's January 13th, 2021, because I got 30 for 30, because it was a non-violent offense.
Okay, so at this point, this matter is not even eligible to be expunged.
No, she told me that I can apply for my expungement in December when going into the next year. Yes.
Okay, so once the non-adjudication time expires, at that point, you can request an expungement.
Yes, sir. But it's not showing up now. I just had a background check done for Georgia. It's not there, and I just got a clearance letter from Georgia. And I had to have a hearing there too, and the judge stated as well, if it's not a non-adjudication, it's basically not a ruling yet, so they can't rule on it. I have that letter here as well.
So are you licensed in Georgia as well?
I have a multi-state, so it covers Georgia. But I have to work and be fingerprinted as well. Yes, sir.
Okay, so this charge in no way affects your license in Georgia either.
No. If Mississippi is my first state, so it kind of does, because my multi-state will be included with Mississippi as being number one, and saying that I can work more than one state, but Mississippi is my home state. And I can't do Georgia until I've been there 18 months, and I haven't been there 18 months yet. I can apply, but they told me that with the multi-states, if it's state to state, because some people come and they go. So if I apply, it used to be an endorsement that they'll give you and you work there under endorsement, but multi-state now, she says, as long as Mississippi is, I have, license in Mississippi, my license are good in Georgia as well, as long as my background checks are clear.
All right, thank you.
The state would direct the board's attention to exhibit B8, page 2, wherein you will find the criminal probation order relating to the respondent.
Okay. All right, thank you both. At this time, I will entertain a motion for close determination.
I'll make the motion for close determination.
Been moved. Is there a second? It's been moved and properly seconded. Ready to vote? All in favor, please say aye.
Aye. Aye.
Any opposed? Passes unanimously. This time I'll entertain a motion for the board to enter executive session to consider this matter.
We'll make the motion in our executive session.
Been moved. Is there a second? All in favor, please say aye.
Aye.
Any opposed? Passes unanimously. At this time, the board will enter to executive session to deliberate on this matter. We will be back in a reasonable amount of time with our decision. Thank you.
But y'all gonna send her a written notice?
Well, we'll come back, Mr. Powell, and announce it, but you will receive.
Oh, yes, sir. Okay.
Okay, thank you. Okay, we are back on the record. At this time, entertain a motion to return to regular session.
I'll make a motion.
Is there a second? All in favor, please say aye.
Aye.
Any opposed? Motion passes unanimously. We are back in regular session. In the matter of Shaleria Palmer, license number P326161, the board renders the following decision, a copy of which will be forwarded to Ms. Palmer via certified mail. There will be a formal reprimand, a $250 fine, an ethics course requirement, in addition to a legal aspects course requirement, and probation that will run concurrently with the non-adjudication order issued by the court. Thank you for your appearance here today. You are excused.
Thank you.
Hold on, there's a question from my multi-state.
What you mean? We are adjourned, is that correct?
Ms. Dickerson?
Yes, ma'am.
Yes. I had not heard from you, so I'm glad to see that you joined Zoom today. I just need to know the course of how we're going to proceed because the individuals that have had hearings have called and we have confirmed times. So we have another hearing that's about to begin, and then we have another one at 11:30, and then another one at 1:30. So I just need to know from you how we're going to proceed, and I want to give you options. Option one.
I'm sorry.
Okay, yeah, option one, you can sign a surrender of your license. We can send that paperwork to you.
Option 2, we can proceed with your hearing today. Option 3, if you'd like to plead guilty to the charges and we will then continue with the hearing, we can do that. Those are the 3 things.
Okay, I just don't understand what you said. You hadn't heard from me. I emailed the Thompson email.
Yeah, I
And-
didn't get any information. No, what did you email me? Because what I emailed you were all the exhibits with the Zoom link, but I never heard from you in terms of what you were gonna do, if you were gonna participate, if you weren't.
Oh, I'm sorry. I thought the first email when I sent that I said that I would be attending the October 7th at 8:30 a.m. And then I got an email back from you, and I thought that was just me saying that I was going to participate.
Okay, well, I need to go back and look at that email because again, we assigned times today and we did not assign you a time. And so are you wanting to go forward with your hearing today?
Yes, ma'am.
Okay, will you be pleading guilty to the charges you received or not?
Guilty.
Okay, that's what I need to know. So what we need to do is schedule you then for probably 2 o'clock.
Okay.
You have any do you have any further exhibits or witnesses? Because I never heard from you on that.
No, ma'am. I have nothing.
Okay, all right, well then that's what we'll do.
Alrighty. On the same meeting call?
Yes,
Okay, perfect.
thank you.
All right, thank you.
No, I didn't get anything from her. I wonder if she emailed Casey, because Casey was her MVP person. And I'm searching my email.
Um, hello, this is Katie Conyers. Is this working?
Hear you.
Yes, we can hear you. Thank you for being here.
Oh, I'm so
next-
sorry.
Okay, next before the board. In the matter of Mississippi license number R896366, case number 2019-0290. My name is Edward Wiggins. I will serve as the hearing officer for this matter and direct the course of these proceedings. Will rule on objections to questions or evidence raised by the parties to the hearing and see to the orderly process of the proceedings and that it is conducted in accordance with applicable laws and rules. Next, I will ask that the board members introduce themselves, starting on this end.
Sandra Culpepper, LPN.
Mary Stewart, RN.
Laura Moore, APRN.
Thank you very much. Is the licensee present?
That is correct. Yes, I'm here.
Please state your name.
Katie Conyers.
All right, thank you, Ms. Conyers. Would you confirm that you've received notice of this matter?
Yes, sir.
Are you represented by counsel?
I am not.
Okay, do you understand that you have the right to be represented by an attorney?
Yes, sir.
Do you also understand that you have the right to present witnesses and evidence on your behalf?
Yes, sir, I do. And I also have a couple of more things that I'd like to add to the exhibits.
We'll get to that.
Okay.
Do you further understand that you have the right to cross-examine any witness who may be testifying against you?
Yes, sir.
Finally, do you understand that you have the right to subpoenas to be issued by the board on your behalf?
I'm so sorry. Could you repeat that?
That you have the right to have subpoenas issued by the board on your behalf?
Yes, sir.
All righty, I will advise that the hearing will proceed as follows. We will have opening statements. Then the case against the licensee will proceed. You'll be allowed to cross-examine witnesses testifying against you, present testimony on any rebuttal to the registration that should be denied. Questioning of the witnesses will start with direct examination, cross-examination, then redirect examination. At the conclusion of the presentation of both sides, closing statements will be allowed. The board will then make findings of fact and conclusions of law and will render its decision in the matter, a copy of which will be sent to the licensee. At this time, I'll ask that all witnesses be sworn in.
Yes, Ms. Conyers, we have Mr. Josh Dilworth, but we do not have Mr. Patterson. Do you know if he's going to be joining today? Because we have to lock the meeting.
Oh, sure. He should be here. Let me, he says it's locked by the host. He said he logged in at 9:29. He's tried 4 times now. He says I'm logged in, but it keeps saying it's locked. I'm going to say try again now.
While we are waiting for your witness,
Sure.
I know that you've received the charges, and I know Mr. Wiggins has advised you of your rights. Just for the state's understanding, is it my understanding you will be pleading guilty to the charges or not guilty?
That's not guilty, ma'am.
Okay. Okay. And we don't see Mr. Patterson.
Okay. Could we proceed with swearing in Josh while we're waiting for Tyler? Could we do that?
Well, your hearing is at 10.
Yeah, we can try to give him a few more minutes to get on.
Right. Well, would it be beneficial to maybe to address the other preliminary matters while we maybe wait to see if the other witness will join?
Yeah, he said he's been trying. Just a second.
Okay.
We'll go ahead and proceed with any preliminary matters, council.
Thank you. Ms. Conyers, you did receive from the state, I believe, exhibits B1 through B9, and then your R1 that you had submitted,
That is correct.
correct?
Yes, ma'am.
Okay, so at this time, at this time, as I mentioned in your email, these are the exhibits before the board panel, and the state would just object to R1 being admitted as those exhibits are outside the timeframe as it is relevant to the board's case today. And I would ask from the state's point of view and motion that they be stricken. So do you want to respond to that?
Absolutely. I believe that this exhibit is pertinent. It's extremely important. I feel like is an absolute answer and a complete explanation. Without this testimony, it just would be pertinent to have.
The state's response would be that, you know, we are not here to retry your case with the Tennessee Board of Nursing. I believe that the Tennessee Board, the final order was February of 2020. And and I understand that the incident in question that the Tennessee Board references was actually, let me find that fact. The time frame that the Tennessee Board is referencing is December 6, 2018. And these screens, again, notwithstanding that we're not here to retry Tennessee, but all of those screens are just not relevant to the matter before the board because you are charged with an out-of-state action. And that
Okay,
would
sure.
be the state's position.
Well, okay, I need to clarify what I am saying I am guilty. There are several allegations, and I need to clarify which one I am saying I am guilty to and which one's not guilty. I do plead that I am guilty to what occurred, that Tennessee did restrict my privilege of practicing in the state of Tennessee. That is a fact. I do not refute that. That did happen. I'm here to offer an explanation as to, you know, that how that occurred, but it is a fact and it did happen. And I do plead guilty that, yes, I did lose my privilege to practice in Tennessee. But the other allegations, I plead not guilty to, and I have the exhibits for that plea. Is that, I'm not really know what I'm, you know, I'm not familiar with this process, I guess is what I'm saying.
So Ms. Conyers, does this R1 exhibit support what you're referencing in Tennessee?
And I'm sorry, and which exhibit is that? I'm sorry.
The R1 with the LabCorp.
These
LabCorp
are
document.
these are exhibits to support that there are allegations that I had narcotics on me. That's not true. I have allegations that state that I guess that I need these in front of me. I'm so sorry. Could you please, how many allegations are there in total? I'm sorry.
The state would just say that again, all of this is referenced in the Tennessee order. The Tennessee found as a finding of fact is on page 2 of the order, the very allegations that the Mississippi Board of Nursing is alleging against your license. So
Okay.
the information that's in the complaint all comes from the order that was issued to you by the Tennessee Board.
Sure. Okay. So the order that was issued was by default because I was not present. So though I can't refute that they did restrict or that they did revoke my privilege to practice there. I cannot refute that because that did happen. However, it was found by default due to me not being present to plead not guilty, to give my case and defend what had happened that day, the day in question. So
And I understand that. And I do understand that, Ms. Conyers, but the Mississippi Board of Nursing should not take up the Tennessee matter.
that's correct.
That's not, that is not what they're here to do today.
Okay, so the matter that we're taking up today is that I'm alleged to have had narcotics on me.
No, the matter we're
No.
taking up today is that you had an out-of-state action posed against your license or privilege. That's the charge D, and that from that charge, there was an additional one about that you engaged in conduct likely to deceive and defraud based on the findings of fact that the Tennessee Board of Nursing states in their order against your license or privilege, I should say.
I'm sorry, I'm just trying to review that paperwork, those orders there. So I guess what I have here is just a misunderstanding on my part as to that these are not separate issues that we're addressing today. Is that correct? This is all one together. Can they be addressed separately or?
I mean, I don't really know what you're saying, because if you look at the charging document that is marked Exhibit B5, not yet entered into evidence.
For
it's
Mississippi.
clear- It's clear on charge 2 on count A.
Okay,
that it
that's what
references
or
the
just in case.
February 12th, 2020 Tennessee Board of Nursing's order.
Okay, so then is it true or false that I need to address these charges and accounts all together under one plea and treat the charges and accounts as one or separately in those accounts?
Well, Ms. Conyers, we're not in a position to give you legal advice on this. That would be a decision that you would have to make.
Oh, okay. Well, then I would like to make the decision that I would like to address them separately, please.
That doesn't answer the question.
I'm so sorry. What's the question?
The state can just move on charge 1 if it simplifies it.
Because I
And-
guess I'm not clear on is if the exhibit R1 does not in any way relate or support what the complaint is about, I don't see why we would need to have this exhibit entered.
It's not relevant to the
Um,
state's position. Again, she's trying to retry the matter in Tennessee, and that's not for the Mississippi Board of Nursing.
So is the charges and the accounts that Mississippi is bringing, are those not the same that Tennessee is bringing?
She doesn't
Because-
understand the complexity of discipline. That's not.
So I'm saying the issue that Tennessee had, is that not also a same issue that Mississippi has?
Well, I think what may get some clarity here is that because of that Tennessee action, Mississippi is in a position of looking at discipline in this jurisdiction. So
Absolutely.
it
Okay.
appears that the documents that you're looking to include were already considered as a part of that Tennessee action.
They were not. They were not.
It doesn't, again, it doesn't matter, Ms. Connors. We can't help you if you don't understand the law here. The law here in Mississippi is that if you have an out-of-state action because
Yes,
you
ma'am.
have a Mississippi license, that
Yes, ma'am.
privilege attached to that Mississippi license is what was revoked in Tennessee.
That's
We have
correct.
jurisdiction then to charge against your license whatever happened with your privilege. That is why we are here today. And the information and evidence you seek to admit before the panel is irrelevant, does not go to the heart of the charges against your license, and is actually prior to the very incident that the Tennessee Board of Nursing references. That's the state's position. It's not relevant. And if you need to go and clear those charges up with Tennessee, that's not up to Mississippi to tell you to do that.
That's correct. I feel that there are charges here that are, parallel with what Tennessee, that order was made under default. And it was because I was not able to present my case. So I would just like the ability to do that here today.
And I would argue that that's not the purpose of this forum. You have a multi-state license. So any jurisdiction that has the home state or privilege could actually take action against license or privilege, Ms. Conyers. And, you know, with all due respect, you know, we don't have jurisdiction. To
That's correct.
To reopen a
I would
matter
just like,
that's already
sure.
been decided.
Sure, I would like it to be considered that their orders or their conclusion came under default with no defense of my own. I understand that they had reached a conclusion. However, I was not present there. So whereas I understand that you are not here, we're not here to decide if that case that Tennessee tried, I understand that you'll have to take that. So with that being said, my plea doesn't change. It is not guilty. And I believe that if I'm allowed to show this exhibit, that it will explain itself. I just,
Not relevant. That'll be up to the panel, but it's not relevant.
sure. It's just testimony of an account of the person that was present that day. And I just didn't have it until today, so.
Well, Ms. Conyers, I don't see the relevance of the exhibit, so therefore I will not allow it to be entered. Was there anything else, counsel?
Yes, there's two things. We need to establish the actual exhibits before the board panel, and that's the state at this time would move exhibits B1 through B9 be admitted into evidence.
Do you have any objection, Ms. Conyers?
I do not.
They'll be admitted.
Secondly, there was an earlier preliminary matter where Ms. Conyers did in writing request that this panel give her an in-person hearing. My understanding is that the board panel decided that she should have a hearing virtually, and I would just like to establish on the record that fact.
So noted.
Lastly, we do need witnesses to be sworn. I believe ample time has been given to allow Mr. Patterson to join us. Is he on? We've had a chance to test the system, and we understand that that's not a problem for him to join. So Ms. Conyers, we need to proceed with yourself and Mr. Dilworth, I think, as witnesses.
That's correct. Yes, ma'am.
Okay, then can they be sworn, please?
So just to be clear, Mr. Patterson is not on.
It's not on.
Okay, may proceed.
Ms. Conyers and Mr. Dilworth, would you raise your right hand to be sworn in, please? Do you solemnly swear or affirm the testimony you're about to give in this cause to be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Ms. Conyers?
Yes, ma'am.
All right, thank you. For the record, I'd like to announce that there is a quorum. These hearings are open to the public. The board may deliberate and make its decision in executive session. We will begin with opening statements, then proceed with the case. Formal rules of evidence do not apply.
Thank you.
I don't believe that Ms. Conyers was heard the oath. She never responded. So
Okay, Ms. Conyers, are you there?
I am.
Okay,
Yes, sir. I'm here.
go ahead.
could I swear you in for your testimony, please, ma'am?
Yes, go ahead.
You solemnly swear or affirm the testimony you're about to give in this cause to be the truth, the whole truth, and nothing but the truth to help you God?
Yes, ma'am.
All right, thank you. Counsel, you may proceed.
Okay. Opening statements. We are here today before this panel as Ms. Conyers has alleged to have an out-of-state action. The state's position is that we have evidence that will prove that Ms. Conyers did indeed have her privilege to practice revoked from the Tennessee Board of Nursing. That privilege to practice was connected to her Mississippi home state license. That final order was issued February 12th, 2020. That matter that the Tennessee Board deliberated upon did concern an incident from December 6, 2018. And as a finding of fact, the Tennessee Board of Nursing did include that information in that order that was sent to Ms. Conyers. The board's position is that Ms. Conyers did indeed violate the nursing practice law, and the evidence and testimony will prove those allegations true.
Ms. Conyers, if you have an opening statement, you can make it at this time.
Yes, sir, I do. Just a moment, I have something prepared. I would like to start by saying that I have much anxiety to be here before you on this day. I feel ill-prepared regardless of how much time that I'm given. I don't think that will change. I very much wanted to have legal representation. I do not feel that I can give myself adequate defense on this matter. I was diagnosed with general anxiety disorder when I was a teenager. And I must say that there's nothing general about it. My anxiety, I'm sorry, just need a moment. My anxiety impairs my ability to communicate effectively when it is in its worst state. Having to answer to these allegations, my anxiety is amplified, increased. I fear that I will not come across clearly. I fear my anxiety will hinder my ability to present the truth. I'm writing this letter, I'm sorry. I hope that this statement will assist me in presenting a timeline necessary to explain what has occurred. I'd like to sum up that the events that happened on the day that Tennessee alleged what took place. I did have pills on me that day. They were not real. They were confiscated from my son after he had wrecked his truck and I had taken him to the ER. I would also like to state that I was wrongly given Narcan. There was no effect of this administration. There was no increase of consciousness. I believe it was a bad judgment call upon the EMTs. And that I have taken many drug tests prior due to unrelated events and many since. Given that my history, which does not contain any narcotic related offenses, I ask that this be taken into account when rendering a decision. To answer as to why my privilege to practice in nursing was revoked in Tennessee. At the time that the Tennessee Nursing Board was trying to contact me to notify me that these allegations were to be answered, each notification was given to my parents' address. At that time, there was much turmoil at my parents' home. I just found out that my sister had been sexually molested by a family member and that there was a cover-up. I was at odds with my parents. We were not speaking. And though my father did tell me I was receiving letters from the Tennessee Board of Nursing, I thought this was a ploy to get me to come over. By the time I was aware the concern was legitimate, It was too late. I contacted the Tennessee board only to find that they had reached a decision by default without my presence or hearing my defense. I was not present to answer the allegations, therefore, by default, my privilege was revoked. I attempted to appeal the decision without legal counsel to no success. I am before you today to testify that I do not do pills or drugs and that I have evidence to support this. And with that all taken into consideration, we can proceed.
Thank you, Ms. Conyers. Counsel.
Okay, yes, at this time I will call Katie Conyers as a hostile witness to prove the state's complaint. Ms. Conyers, please for the record state your current mailing address.
It's 307 County Road 514, Corinth, Mississippi.
307
Oh,
County
I'm so
Road.
514. I'm sorry. And Ryan, that's Ryan Z, not Corinth. I'm sorry. It's 38865.
I'm sorry. You said 307 County Road 514?
That's correct.
Okay. And that's Corinth. Okay. All right. I need you to turn to the evidence that was submitted you, and you acknowledged having no objection to him being entered in evidence in Exhibit B5, Exhibit C that's contained in B5. Can you go there, please?
Just a moment. And this is under the exhibit list, is that correct?
Right. Exhibit C is attached within B5.
I'm so sorry, I'm just not seeing. I have it here. I'm just, could you repeat which one it is? I'm sorry.
It's the Tennessee Board of Nursing order.
Okay, go ahead.
And would you agree with me that this order was issued February 12th, 2020?
That is correct.
Okay. And would you agree with me on page 2 that the Tennessee Board of Nursing made some findings of fact?
By default, yes.
Okay. And would you agree with me that, as it states in paragraph 1 under findings of fact, that it states that at all times you were licensed by the Mississippi Board of Nursing as a registered nurse, having been granted license number 896366 on February 5, 2014?
Yes.
Okay. And would you also agree with me that you were practicing in Tennessee on the privilege afforded you by the Mississippi multi-state license under the Nurse Licensure Compact?
Yes, ma'am.
Okay. Then would you agree with me in findings of fact in paragraph 2 that from August 28, in terms of what it says in the order, in August 2018 to July 2019, that you were employed as a registered nurse, West Tennessee Healthcare in Dyersburg, Tennessee?
That is correct.
Would you also agree with me as the finding of fact in paragraph 3 from the Tennessee order that it states on or about December 6, 2018, Jackson Police Department officers responded to an overdose situation regarding respondent in Jackson, Tennessee.
That's incorrect.
Is that what it states in the order?
It is what it states in the order. Yes, ma'am.
Okay. In paragraph 4, would you agree with me that it states in the order on or about December 6, 2018, an officer with the Jackson Police Department found respondent with Xanax and hydrocodone tablets in her purse?
That is what was believed to begin with.
Is that what it states in the order, Ms. Conyers?
It is what it states in the order. Yes.
Okay, then I want you to go within Exhibit B5 and look at the Mississippi Board of Nursing charges against your multi-state RN license.
Which states?
It has charge 1 and charge 2.
I'm sorry, I'll have to pull up that separately.
I can't, B5.
And I'm sorry, could you repeat the question again, please?
I sure can. Well, actually, I just wanted to make sure you got to the Mississippi charging document. It's got Exhibit A and it's got charge 1 and charge 2 on the page. Do you see that?
No, ma'am, not yet.
Okay.
You're welcome to reference it if you would like to continue.
Well, I need you to have it in front of you.
Okay.
And it should be the 3rd page of Exhibit B5, if that helps.
The 3rd page of exhibit. Okay. I think I found it. How many pages in total are on this?
It's Exhibit B5. The first page of Exhibit B5 is your notice, and it's dated March the 6th.
Oh, okay. Yes, ma'am. Sorry. I do see it. Yes. I'm sorry. Go ahead.
Okay. Just want to make sure we're talking the same language here. So
I'm literally
on
on the
this,
same page.
on the Exhibit A document that I'm referencing, would you
Yes,
agree
ma'am.
with me that charge 1 from the Mississippi Board of Nursing is charging you with having a license or a privilege to practice as a registered nurse revoked in another jurisdiction?
Yes, ma'am.
Yes or no? You would?
Yes. Yes.
Okay. And then in charge 2, would you agree with me that the Mississippi Board of Nursing is charging you with having engaged in conduct likely to deceive, defraud, or harm the public? Would you agree with me there?
And I apologize. Am I agreeing that?
You're agreeing? That's what it states. That's what it states.
So I am aware that Mississippi is charging me with that. Is that what you're asking?
Yes.
I am aware. Yes.
Okay. Now let's go to count A. Would you agree with me? Just in earlier testimony, you agreed with me that the Tennessee Board of Nursing issued you an order dated February 12th, 2020, revoking your privilege to practice in Tennessee, correct?
That is correct. Yes, ma'am.
And then if you go down to that next paragraph under count A, would you agree with me that that statement on or about December 6, 2018, Jackson, Tennessee Police Department officers responded to an overdose situation regarding respondent in Jackson, Tennessee? Would you agree with me that that statement is the exact same statement located in paragraph 3 under the findings of fact in the Tennessee Board of Nursing order?
I'm sorry. Okay, so we're literally just establishing that I'm aware that Mississippi is charging me with the same thing that Tennessee is. Is that true? Is that what you're saying?
That's what I'm trying to get to understand from you. You acknowledged earlier testimony that you acknowledged in earlier testimony that paragraph 3 under the findings of fact from the Tennessee Board of Nursing, that that's what it stated, right?
I do. I am aware what is stated in the order. That's correct.
Okay. And I just want to make sure it reference that I'm making the point that Mississippi is charging the same thing from Tennessee.
That is correct. Yes.
Okay. And then on the second page of Exhibit A, it says on or about December 6, 2018, an officer with the Jackson, Tennessee Police Department found respondent with Xanax and codeine tablets in her purse. Is that what it states from the Mississippi order?
It is what it states. Yes, ma'am.
Yes. And would you agree with me that that is the verbatim language found in the Tennessee order in paragraph 4 under findings of fact?
The text is the same. That is correct.
Okay. All right. So you would agree with me then that the Mississippi Board of Nursing charged exactly what Tennessee Board of Nursing charged?
The texts are the same. Yes.
Okay. And do you understand that the Mississippi Board of Nursing, because it granted you a multi-state license, that Mississippi is the home state?
That is
You
correct. Yes, ma'am.
Okay. And you understand that before you today, Mississippi has the authority to hear a matter if you've had an out-of-state action. Do you understand that?
Yes, ma'am.
Okay. And you're going to agree with me then that you had an out-of-state action, correct?
Yes, ma'am.
Okay. Now you argue that you were not present, correct?
That is correct.
Okay. But it doesn't change that the Tennessee order still is effective. Would you agree with me?
That is correct by default. Yes, ma'am.
And you stated earlier that you had the opportunity to appeal, right?
Yes, ma'am.
Okay. And in the Tennessee order, on page 6, actually, and this is in Exhibit C, you actually had 3 different opportunities to appeal this order. Would you agree with me?
That is correct. And I did attempt to do that, ma'am. Yes.
Okay. And did you supply any of that information for the board today?
I believe so. I believe that it was entered into the exhibit from y'all. I believe. Yes.
Of your ability of your attempt to appeal?
Y'all sent me everything from Tennessee. I believe it's in there.
Okay, can you point to me that exhibit number because I don't see it?
The attempt to appeal. Sure. The exhibit number would be. Are you saying that you don't have this in your records? Is that what you're saying?
I'm saying you're saying that you appealed the Tennessee board order.
Yes, ma'am.
We don't have any information to that effect. So I was asking, did you have it? Did you supply it to us? I don't have it.
I apologize. I assumed that it was in everything that y'all sent to me. I'm looking through it now. There's a lot of papers.
Yeah, and I believe you
Here.
started getting all these exhibits back in June. Would you agree with me on that?
Yes, ma'am.
All right. Now, Ms. Conyers, you mentioned in some testimony that you were not currently taking medication. Is that true?
No, ma'am. I am on medication.
Okay, and what medication are you on?
I'm taking Pristique, 100 milligrams. Currently and presently, that is all that I am taking.
Okay. In B8, there is a pharmacy profile that was admitted into evidence.
Yes, ma'am.
Okay. And so the last prescription that was filled by you states here it was in July of 2019 for clonazepam.
Yes, ma'am. And I believe there is actually one even a little bit more current than that. Occasionally, I am prescribed clonazepam. That is correct.
Is there anything else that you are taking that you take occasionally?
I believe it's been over a year, but I was taking diet pills at one time, but it was just on occasion. I believe it's been over a year since the last time I was taking diet pills. That would also show up on the scheduled list.
Do you get all your medications filled in Mississippi or are some filled in Tennessee?
In Mississippi, ma'am. Oh, occasionally I will fill in Tennessee because I do travel there often. But I believe we have all the information. It's all the same prescriptions that we have in front of us now.
Okay, and given the action from Tennessee, Ms. Conyers, again, this is your personal paper to the board based on this order. And just curious, did you seek treatment or have counseling as a result of what Tennessee found?
Yes, ma'am.
You have, okay, and what did you do?
I'm sorry, I need to clarify. I just received therapy on a regular basis. I received therapy for just the stress that those events that happened. So when I received therapy, I did get therapy about what happened in Tennessee and how stressful that was. And so, yes.
Okay, and how long were you in therapy?
I am currently still in therapy.
And your diagnosis, as you stated in your opening statement, I believe, was generalized anxiety?
Yes, ma'am.
Okay, and you're not prescribed anything for that?
Well, the clonazepam, occasionally I am, and then the Pristiq. Pristiq is what I have been taking for years. The clonazepam is a PRN basis, and I'm not prescribed it currently.
Are you seeing the same provider?
Yes, ma'am.
Who would that be?
The place that I receive therapy in would be Region 4 Mental Health Services, and they do change physicians often. They have a little bit of a turnover, but for a year I was under Alicia Watson, and she would be for the last year, all the prescriptions came from her.
Okay, and Ms. Conyers, the reason I take you down this line of questioning is I want you to
Sure.
understand is that you say that it was a default order from Tennessee and that you are fine and that you are fit to practice, notwithstanding your treatment of your general anxiety disorder. However, the board panel has zero documentation for them to consider to prove that you are fit and competent and safe.
I was unaware that was in question.
Well, did you read the findings of fact of the Tennessee Board of Nursing?
The Tennessee Board of Nursing?
That's right.
Are you saying that it says that I'm not competent?
Well, what I'm saying is, if you have an order from the Tennessee Board of Nursing charging you or finding as a finding of fact that officers responded to you as an overdose situation and that they found Xanax and hydrocodone tablets, and then Mississippi is charging the exact same thing, given what Tennessee Board of Nursing, do you not understand that the board panel might be a little cautious about thinking that you should have a license to practice?
Oh, wow. I'm sorry. That was a heavy question. Okay, so the pills that were found there, it was obvious that they were not Xanax and oxycodone. They never brought any charges against me.
And I would object to that testimony, as we do not have any evidence to substantiate that.
Because it doesn't exist.
Well,
that's why.
But Ms. Conyers, I hear what you're saying, but from a legal standpoint, the Tennessee Board of Nursing has as a finding of fact, and there's nothing that you've provided to dispute that today.
I can't provide a document that doesn't exist, but I can state that I have not been charged with possession of narcotics.
So noted.
I can state,
Yeah. The board would not, the board would stipulate you've not been charged.
oh, yes, ma'am. Okay, thank you. Yes, I was never charged with possession of narcotics. The officers did not bring those charges against me because it was obvious that they weren't oxycodone or Xanax. They were not real pills.
And that is your testimony, but again, the state would object to that testimony as there's no foundation or evidence to substantiate that fact.
Right. That's correct. It is just my testimony, as well as the fact that there is no evidence of possession of narcotics from the state of Tennessee.
Let's go to B7.
Yes, ma'am.
Okay, and do you have it in front of you, Ms. Conyers?
Yes, ma'am.
And I want to turn your attention to page 2.
Yes, ma'am.
Would you agree with me that this report that is from the state of Tennessee Office of Investigations that was rendered against you is the information that's also contained in the finding of fact in the Tennessee Board of Nursing? Would you agree with that?
The text is the same.
Thank you. At this time, the state has no further questions. And would rest.
Thank you, counsel. Ms. Conyers, you can proceed with your case.
Yes, sir. And what is your name? Who I'm speaking to? I'm sorry, sir. What is and what is your name? I'm sorry.
Wiggins, Edward Wiggins.
Okay, Mr. Wiggins, and in your role, I'm sorry, is just kind of presiding over the hearing and just kind of you direct it. Is that correct? Okay. Okay, so all right, I would like to discuss with a witness.
Who's your witness?
Joshua Dilworth. Josh, are you there?
Yes, I am.
Okay, how long have you known me?
Almost 3 years, 2.5.
In those 3 years, have you ever known me to be on any other medication than what's prescribed to me?
No.
Have you ever known me to take any substances that weren't prescribed to me?
No.
Or can you tell me, could you tell the board how often that I go out or drink with my girlfriends?
Not often.
Could you be more specific?
Less than 2 or 3 times a month.
Okay. And do you know me to become intoxicated beyond competency or being able to talk or walk or anything like that?
No, not at all.
When you have witnessed me hanging out with, let's say, Laura or a girlfriend of mine, how much alcohol would you say I consume?
3 or 4 beers, if that. After that, you just kind of quit.
Okay. The other night when we were at Laura's, how much wine did you see me consume?
I think just 1 glass.
That's correct. And were we close? Did we have a close relationship in October of 2018?
I believe so, yes.
Are you aware of the events that are in question on Tennessee with an ambulance being called to the scene?
Yes.
Do you know why an ambulance was called?
I know why they said it was called.
Do you know why an ambulance was called?
Yes.
Why was that?
I believe you were unconscious.
And where did you hear that?
It was,
Are you aware that that I have issues with blood sugar?
yeah,
Okay, and are you aware that the ambulance was called due to the fact that I was groggy and that I wasn't talking, and that I worried my friend Abigail that was there that day?
yeah. I mean, I don't think you were called due.
Witness, I'm sorry, can't respond yet. I'm gonna have to object to the question. The witness is testifying and not asking direct questions. It's leading.
Sustained. Ms. Conyers, if you can, please pose questions to your witness for him to answer.
Sure. Did you see me on the day that an ambulance was called?
Yeah, later that day, yes.
And could you please describe how I was acting or my constitution that day?
You were stressed out, I believe, earlier that day.
Was I awake? Were my eyes open? Was I
Yeah,
thinking?
yeah.
Did I receive medical attention further from Tennessee that you're aware of?
No,
Thank you. Since that occurrence, has that occurrence happened again?
no, not to my knowledge.
And do you live with me?
Yes,
Okay. And do you see me consuming anything illegal or that I'm not supposed to?
no,
Are you aware of the possession of pills that she was found with that day?
no,
Okay. Do you know where I got those pills from that day? Where I had got them from?
yes,
Where did I get them?
from your son.
And how did I get them from my son?
I don't remember when, but I know he had a wreck and you had to go and get him from someone's house and you got him from his vehicle.
That's right. And can you please state, did you see me throw those away?
No,
Are you aware that those were taken by police on the day in question that an ambulance was called?
I am now, yes.
And do you know of any charges of possession that Tennessee has brought against me since then?
No,
Have you heard anything else from Tennessee about charges being pressed against me for possession of narcotics of any kind?
no,
In your opinion, no, I'm sorry, I don't want to ask that. Could you please tell the board about what kind of nurse I am that you know of?
great nurse. I mean, you treat me like a patient even when I'm just common cold or something. You can tell you really care.
And could you please tell the board, in your opinion, how much my career means to me?
It's everything.
Do you believe that I would jeopardize my license with substance abuse or anything like that?
I do not.
Are you aware of any plans that I have in the future regarding my career?
Yeah.
What are they?
You would like to travel I believe it's up north somewhere.
And do you know anything about any further schooling?
In the field of nursing?
At all? Any kind of
Oh.
aspirations at all for education further?
You want to go to lawyer school or law school?
So that I can become, do you know what?
I assume a lawyer, but I do not know what kind.
Nurse lawyer. That's correct. Is there anything that you would like to tell the board about me today? About my character, or could you elaborate to the board my character?
That she's just a great woman. She comes off a little confused or something. She's just really stressed. This whole ordeal is, it's affected both of us. And I think it would affect anyone like that.
And could you please tell the board that how you feel about me as a mother?
Better mother than mine. She does care a lot. It's ridiculous. It's obsession is what it is.
Thank you. I don't think I have any more questions for him at this time.
Okay, thank you, Ms. Conyers. At this time, council will have an opportunity to question the witness.
Just a few questions, Mr. Dilworth.
Yes, ma'am.
Were you present with Ms. Conyers on December 6, 2018, when the Jackson Police Department officers responded to the overdose situation?
I was not.
I'm sorry?
No, ma'am, I was not.
Okay. And were you present when the officers on December 6, 2018 found Xanax and oxycodone tablets in her purse?
No, ma'am, I was not.
Okay.
And
No further.
sorry, go ahead.
Okay, Ms. Conyers, if you have some redirect, you can make that at this time.
Would it be possible to refer to these tablets as alleged oxycodone and alleged Xanax, because there was never any drug testing done on them?
I would object, as the stipulation, or excuse me, judicial notice should be taken of the findings of fact in the final order, number one. And then number
The
two,
findings,
counsel testified earlier that she agreed with me that the findings of fact indeed said exactly what was read to the witness.
the findings of fact do not include exhibits of any testing on those substances that day.
And that's not what counsel asked to Mr. Dilworth.
Okay. All right, I'm sorry. Go ahead.
Question, if you have some more questions, Ms. Conyers.
No, sir, I don't. No, thank you.
Okay, any further witnesses?
No, sir, I just have the exhibits of the drug tests that's been done. One was including a hair test, as well as the urine tests prior and after.
Right, and Ms. Conyers, we've already ruled on that. Those drug screens are not admitted because they're not relevant to the matter before the board today.
Do you have anything else to share with the board, Ms. Conyers?
Is the board considering if I'm taking narcotics or that I took them? I would like to testify
Conyers,
about what happened that day.
Conyers, the
Yes,
board
sir.
all testimony and of course the exhibits that have been presented. Do you have any further questions for Mr. Dilworth?
I do not.
Okay. Do you have anything further for Mr. Dilworth, counsel?
No, the state does not.
At this time, we will move to closing statement. Oh, I'm sorry. Questions from the board?
Did Ms. Conyers testify?
I have not yet. I would like to.
Okay. Ms. Conyers, you can go ahead with your testimony. Then if we have some questions from the board, we'll deal with those. Please proceed.
Sure. Just a second. I have something I'd like to pull up. I have a letter written from the person that was with me that night. I'm sorry, that day. Am I able to read that at this time?
Give me a copy of this, counsel.
I was not given a copy of that, and so the state would object to her being able to read a letter.
Do you have a response, Ms. Conyers?
Just that I'm sorry that I haven't sent it to her prior. I would love for her to be able to look over it and have an opportunity to read it before I read it out loud if we needed to do that.
Pursuant to the rules of procedure in 2825, Ms. Conyers,
I understand. I'm sorry.
opportunity was given for you to submit those exhibits. You've not done so,
Sure.
so I'm going to have to object on the grounds that you have not complied with the rule.
Sure. I'm sorry. That's fine. I can just proceed then.
You can go ahead with your testimony.
Sure. Okay, I'm sorry. Okay, on October 6th, 2018, I had gone out with a nurse friend of mine, as well as a friend of mine named Abigail, another friend named Tyler.
And I'm sorry, I'm going to have to object to this testimony. Again, we're not here to retry the Tennessee Board of Nursing matter. Her ability to replay the facts that have already been decided by the Board of Tennessee would be out of the jurisdiction of this board to consider.
So they don't want to hear what events occurred the day in question?
Okay, what the event you're attempting to describe, Ms. Conyers, does that relate to the issue that was decided in the Tennessee board?
Yes, sir.
Okay, at this time, we do not need to consider that because we have a final order from the Tennessee board regarding that matter. Is there something else you want to share with the board?
That I was not present at that, when that order was made. It was made on default. And so I was not able to present a case when that order was made. I would like that to be considered.
Okay, we will definitely make note of that. Is there anything else you'd like to share?
Does the board have any questions for me?
Council, do you have any questions for her?
No question.
Do any of the board members have questions for Ms. Conyers?
May I ask Mr. Dilworth? Mr. Dilworth, thank you for being here. I have just one question. What is your occupation?
I work at Lowe's. I'm a fulfillment team lead.
Okay.
Basically, take the online orders and stuff.
Okay, thank you. And then Ms. Conyers, thank you also for being here. Question, you said you have a history of blood sugar problems?
Yes, ma'am. That's correct.
Okay, so have you had multiple episodes? Can you describe that a little bit more?
Yes, ma'am. That day is the only documentation that I have of record, and I suppose I'm pointing that out because it is on record there in the exhibits that was entered in the ambulance notes there that my blood sugar was over 500 that day. But as far as what y'all have in the exhibits, there's not anything further on that.
So have you been, I'm just curious as to the pattern. So do you have, can you remark about any history of hospitalization related to blood sugar alterations?
No, ma'am, no, there was no other hospitalization. It was the only time that I received any kind of medical attention was that day.
Okay, and would you mind, I know that you're taking Klonopin as needed. When was the last time that you took that?
I believe it's been 3 or 4 months ago. And that was the only time this year I was prescribed Klonopin. I was given one prescription over the past year to take as needed, and I believe there was 15 in that prescription. And that was a PRN. It was the only time this year that I've been prescribed that.
And you're taking the Pristique for what?
Generalized anxiety disorder. It's also to treat depression, but I take it for anxiety reasons.
Do you find that it's helpful?
Yes, ma'am, I do. I know it doesn't look like it today, but yes, ma'am, I do.
Okay, thank you.
Anything further from the board?
I did.
Go ahead.
Ms. Conyers, I just had a question. And I'm kind of
Yes, ma'am.
on Dr. Stewart, because my question as well was in regards to your blood sugars. And
Okay.
when you were talking about your blood sugar being 500,
Yes, ma'am.
had you been drinking that day?
The night before I had, yes, ma'am. And that morning I'd had like something like 2 or 3 Red Bulls. It was not healthy. No, ma'am. But yes, I had been drinking the night before.
Okay, and
I had not slept.
And this is just for some clarification from me.
Yes,
Based
ma'am.
on looking at your PMP, you do not believe you have an issue with controlled medications, is that correct?
That's correct.
Have you
And I'm
attended
sorry.
any other organic or perhaps natural, such as counseling to deal with your anxiety?
And I'm sorry, I couldn't hear you. Could you repeat that, please?
Have you attempted in a more organic or natural way to receive counseling for your anxiety versus the medication?
Yes, ma'am. Yes, ma'am. I go to therapy, and I go several times a year. I go more if I need to. When things get bad in life, I'll go every couple weeks. But yes, ma'am, I do pursue. I also work as a mental health nurse at times, so I'm aware of all those, and I do use that opportunity to, to seek out further like counseling and therapy and such.
And I guess to kind of wrap up my last question for you, you
Yes,
stating
ma'am.
that you work as a mental health nurse. Would you be willing to submit to a chemical dependency evaluation if we so choose?
Yes, ma'am, absolutely. Yes, ma'am. That's absolutely. I'm not sure if y'all are aware of my history with my nursing board license. When I was younger, in my early 20s, I had gotten a DUI. Before I got my nursing license, I had volunteered to go on a 24-month like drug testing every day, where I checked in. I forget what the name of the program is that the nursing board offers or does, but I volunteered to do that to just show that I didn't have any problems with drinking or substance or anything. I went the whole 2 years without even a glass of wine, and I checked in every day. I had to undergo random drug tests every day for 24 months, and that was it was expensive, but it was worth having my license and being able to work and do all that. And so, if I had to do anything like that, I would be absolutely thrilled to show the board that I have no chemical dependency problems at all.
Well, one more question.
Yes,
So
ma'am.
if I'm understanding your last statement,
Yes,
Ms.
ma'am.
Conyers, are you letting us know that the board has monitored you before?
That is correct. That would have been in the first 24 months of my, when I first got my nursing license. I volunteered to do that.
Any further questions from the board? Anything else you'd like to share, Ms. Conyers?
Just that I just wanted to reiterate that that was on a volunteer basis that I did do that program. And that, and given the chance, I would do that
Yeah, Ms.
again.
Connick, I believe it was the MAP program at the time, the non-disciplinary program.
That's correct. Yes,
fine.
ma'am. Yes, that's correct.
What time frame was this?
That would be in the first 24 months of receiving my, getting my nursing license to begin with.
2014 to 2016. Since she opened the door to that.
Is that a bad thing?
No, you offered that as your response. So I'm just stating that I just need the board panel to know that was a non-disciplinary confidential document at the time that you signed with the Board of Nursing.
Oh, okay. Yes, I don't have anything to hide.
Right, and my point was that was testimony you elicited.
That's correct. Yes. Yes, ma'am. But all of those drug tests that I did in 24 months are monitored, and I not once ever was positive for anything. And again, that was a non-disciplinary.
Thank you, Ms. Conyers. At this
You're
time,
welcome.
we'll begin with closing statements.
Very briefly, it should be clear by the testimony and the evidence provided you today that Ms. Conyers is indeed guilty of violating the Nurse Practice Act. The first charge is that she has an out-of-state action from Tennessee. Arguably, she wasn't present, but again, I don't think that the board should focus on the default as much as you focus on what they have to put in those legal orders and have to be defensible for their job to protect the public. In the same vein, when we're given a nurse alert on a nurse from another jurisdiction that says that they've has a finding of fact, they've been called to the scene for an overdose and they found pills on them, there may be an explanation. There may be other factors. But again, if it cannot be held up in court and defensible, and if it's written in the order, then we as the board, especially board staff, have to rely on that information from other jurisdictions. You've heard today that Ms. Conyers she says she's got a generalized anxiety disorder. She goes to some counseling. She feels that she's safe. But I focus on, we have no evidence to suggest that. We have no drug screen to show that she is currently okay. We really don't have an idea of all that she's on based on her testimony that she's getting some medications from Tennessee. And we don't have the jurisdictional power to subpoena any of those records from Tennessee as it relates to the PNP. That's under a separate law that protects that information. All that to be said, what do we have? We have an order from the Tennessee board that revoked her privilege. That privilege was revoked in connection with her home state Mississippi license. You as a board today have to decide what, if anything, to impose against Ms. Conyers' license. We offer today, as the evidence testimony suggests, Ms. Conyers is guilty of both charges. And should you think that Ms. Conyers has a chance or you want to give her some type of chance, the state would just argue that you certainly supply many conditions and many stipulations because, again, your job is to protect the public, not to go on the word of someone that's been already charged, already adjudicated, and has provided nothing for this board to consider as to her competency. Thank you.
Ms. Conyers, you can make your closing statement at this time.
Sure. I've provided drug tests that have been done since the occurrence or the events. They're all negative. All the ones prior negative, including a hair test that was even done. I am a safe nurse, and I'm a good nurse, and I love my job. I apologize for my emotion. I'm a single mother, and my nursing career means everything to me. I know that order is important about what happened in Tennessee. Please consider that I wasn't able to defend my matter on that day. I could not afford an attorney for this, though I really wanted one, because my license has been frozen since these came up, and I did not have any savings. I have 2 children that depend on me, and my son just entered into college at Mississippi State, and there's just a lot of people that rely on me and my nursing career to support my family. I hope you know that I'm a good nurse. I love my job. What happened that day was very unfortunate misunderstanding. And I apologize that I don't have enough evidence to give to you on paper, but I can tell you that the EMTs should not have given me Narcan that day. There was no reaction to Narcan. I did not become more aware or awake. I know what Narcan is supposed to do. I've given it many times. They should not have done that. And like I said, since then, I've taken many urine tests, which I have entered into exhibit. I don't take drugs. I don't do drugs. I'm a good nurse, and I'm willing to do anything to prove that and show that. And again, I apologize that I about that order in Tennessee. I understand I've lost my privilege to nurse in Tennessee, and I hate that because I worked a lot in Tennessee. I would just like the opportunity to defend myself about what happened on that day, and I just wasn't able to do that in Tennessee. And again, I can't refute that I lost my privilege. I just hope that you take all of that into account when you decide. Just please let me keep being a good nurse. I am safe for the public. I believe I provide a really good service working in mental health. I connect with my patients. I love what I do, and I'd like the opportunity to keep doing it. Thank you. That's all.
All right, thank you, Ms. Conyers. Anything further from the board? At this time, I'll entertain a motion for closed determination.
That the panel go into closed determination to see if we need an executive session.
Is there a second? Been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Passes unanimously. Next, entertain a motion to enter into executive session.
I move that the panel go into executive session to consider the matter of misconduct.
Is there a second?
Second.
It's been moved and seconded. All in favor, please say aye. Any opposed? Passes unanimously. The board will now enter into executive session to deliberate on this matter. We will return with a rendering that will also be mailed to Ms. Conyers. Board is now in executive session.
We're gonna go ahead and take our
want to in this time while we're deliberating or keeping it?
Until the 11:30 to come back whenever's convenient. We muted Shannon.
Mr. Wiggins,
Yes, ma'am.
could you please explain to me what happens next?
The board is going to deliberate over your case and then will return to issue you a decision. A copy
Okay.
of which will also be mailed to you by certified mail.
Okay, and so do I just stay on for now, or?
If you want to stay on, that's fine. It is
Yes.
possible the deliberation could take a while.
Okay,
And,
okay.
We may go ahead and just have lunch. So
Like
we
a
can be
lunch?
back. Right, so
Sure.
I would say probably be back.
Yeah.
Let's probably plan to be back by 12:30.
12:30, okay.
Yes, ma'am.
And so, okay, thank you, Mr. Wiggins.
All right, thank you.
I think they understand most of their people aren't gonna be versed.
I think I might have messed up. I totally forgot.
next week. Because it's not hot anymore. It's like, we're gonna gain some weight over the holidays. It doesn't say we can still walk.
I said, you know what, I got on heels and I can't walk in heels. I know it's fun. Just fix my step up. Because it just matters, better than how I smell outside. Cause you know how when y'all know what the fresh outside smells like.
Oh, yeah.
It's just so much better. You know, so too. Here, I'm really liking this little jazzy look you got going on.
I know, you look pretty today.
Thank you. Like a grown woman. That's how it is my grandma's church. It goes well with you, I promise. 'Cause I was like, we gotta have it. Yesterday we had it, but today we gotta have it.
I agree, I like it.
It look great to me. Ooh, that smells so much better, Jesus.
Crazy.
Oh, God, we know.
All right, I'm in. Thank you, ma'am.
Oh.
Yeah, well, we can just hang on till she gets back, because we're gonna need that quorum.
Okay.
And I guess, Shannon, if I need to announce that, I can. We gotta wait till Mary gets back.
Hey, can you try to log in on the Zoom again for me? I can't get her back on anyway. I'm gonna hang up, Phyllis.
You want me to go see if she's available, come in right quick?
Who, Mary?
She's right there.
Well, I asked her and she said her,
We come get her. I gotta get these
Okay.
people back in. They're not able to get on the Zoom right now.
Okay.
I just thought we were gonna get a call when she's.
They're saying that it's locked.
I'm good.
Thank you, man.
Okay.
They finna give a whooping.
I know.
Others that we're having, and I've got an ASP.
Can you hear us?
Can you hear me, Shane?
Ma'am, can you hear us?
There is no show.
I can hear you.
Okay.
There's
I
a
just
no
wanted to test
show.
it. Thank you.
And there's a no show.
I can hear you, but barely. Turn the volume up.
And Catherine
I got people in the
I'm in the
office.
corner, so
Okay, that's better.
I'm in the corner, so you can't hear me. I just wanted to test it. Thank you.
All right.
All right, bye.
She wants to continue on because she said that we gave it to the wrong address, which is the address of record.
Hi, Katie, are you there?
Yes, ma'am, I'm here. Can you hear me? Can you hear me? Okay, sorry. Okay.
There we go.
Can y'all see me? Okay, thank you. Meeting topic, Zoom, public access, Mississippi Board of Nursing.
Okay.
Ms. Connors?
Ms. Conyers, are you there?
Yes, I'm sorry. I'm here.
Okay. Thank you for your patience. We had some technical difficulties as well as some other matters that came up. But we are back on the
Same.
record, and I will entertain a motion to return to regular session.
I move that we return to regular session.
Is there a second?
Second.
Been moved and seconded. All in favor, please say aye. Any opposed? Motion passes unanimously. We are back in regular session. In the matter of license number R896366, case number 2019-0290, after deliberation, the panel renders the following. Suspension stayed with drug-related stipulations. To include evaluation for chemical dependency, psychiatric psychological evaluation, a $500 fine,